And our best regular radio program on migration goes to Immigration Law on Your Side, PHLV radio station, Attorney Flomy Diza and Mr. Johan Saison. Congratulations, Immigration Law on Your Side.
Reeves Immigration Law Group now brings you Immigration Law on Your Side.
Good evening, everyone, and welcome to another Immigration Law on Your Side right here at PHLV Radio. It's after the Memorial Day weekend, and it's, well, getting hot out there. At talaga namang unofficial start of summer na. Malapit na yan. Painit ng painit ang ating panahon at painit ang pinag-uusapan natin sa larangan ng immigration. Kaya ngayon, sa ating Immigration Law on Your Side, tumutok mga kababayan because a new USCIS policy memorandum has created significant discussion and concern throughout immigrant communities and among immigration lawyers nationwide. Well, I'm sure napanood yun na sa mga social media that social media is full of anxiety. Clients are asking whether adjustment of status is ending. Is consular processing now mandatory? Should people panic? So ngayon, pag-uusapan po natin, we're all gonna break it down what this memo says, what it does not say, and most importantly, what immigrant families should watch for moving forward. Kasama natin si Atty. Diza once again, papaliwanag sa atin. Magandang gabi sa Atty. Diza.
Magandang gabi, Kuya Johan, at belated Happy Memorial Day sa lahat. At of course, maganda ating pag-usapan ngayon dahil nilabas itong memo na to on a Friday before the Memorial Day. So long weekend yan. And marami sa ating mga kliyente at mga immigrants sa social media messages ang nagtatanong during our vacation, whether the adjustment of status has ended or ano itong extraordinary or is an act of grace. Ano itong adjustment of status? And I understand their concern, Kuya Johan, dahil one of the easiest and fastest way to immigrate and get the green card is through adjustment of status without leaving the country. Kasi pag umalis sila, lalo kung mayroong tawag nito overstay, they will accrue unlawful presence, right?
Yes.
Either 3 or 10-year bar. So there's that problem where they have to leave the family, especially if they are taking care of aging parents or small children, or having a great job in the United States. So leaving uncertainty and going back to the home country is a big concern sa ating mga kababayan.
Talaga namang nagulat ang ating mga kababayan, kaya marami silang mga tanong, attorney, regarding this green card, adjusting to green card, kailangan nang umuwi sa Pilipinas. Palawag muna natin, attorney, balikan natin ng konting definition on what is adjustment of status at ano ang mga examples nito, attorney?
That's a great question. Ang adjustment of status, ang term natin dyan is AOS, is the process that allows eligible individuals na nandito na or physically present in the United States to apply for a lawful residency or tinatawag natin green card without leaving the country. So examples nito yung spouse of US citizens who entered lawfully and qualifies to adjust. Let's say you got married, even if you entered the US 10 years ago, 20 years ago, you have a valid what do you call this, I-94, right? You were inspected and admitted, use your own name, then you can still file the adjustment of status. Now, employment-based applicants already in the United States, for example, you're here on an H-1B, right, or L-1 or E-2, and then you have an approved I-140, and while you're on status, you can adjust, you can change from H-1B into an adjustment of status without leaving the United States. Now, yung mga applicants din na mayroong 245I, yung mga nasa preference category, pwede rin mag-file ng adjustment of status, or people who obtained the asylum status after a year, right? They can file for adjustment of status. Now, for example, Kuya Johan, yung in 2024, now there are more than 1 million who were applied and granted residency through adjustment of status. And last year nga lang, even during the Trump 2.0, there were already about 500,000 who were granted a green card through adjustment of status. So, consular, yun ang adjustment of status. And this has been recognized for many, many years, since the 1950s, Kuya Johan, that, they don't let people go home. And there's this pathway called adjustment of status without leaving the United States.
Mm-hmm. Bahagyan natin nabanggit kanina, attorney, yung consular processing. This is the flip side of it. Instead of processing within the United States, biglang aalis, kailangang lumabas sa United States and magiging consular processing ang kanilang pag-move forward sa kanilang green card process. So what exactly is consular processing, attorney?
Yes, consular processing normally applies for people who are outside the United States. So, for example, you're working or you're in the Philippines or working abroad. Let's say you're in Europe or in Asia and you're waiting for your petition to get approved, petition for you to have your interview. So it's a pathway where the immigrant applicant completes the process, green card process outside the United States. So, but the filing is still with the USCIS. Either here in the US or at the embassy, right? And then once it get approved, ito yung goes to the National Visa Center for processing payment of visas and filing and uploading your documents with the National Visa Center, and you have to wait for your interview at the consulate. So that's what we call the consular process. So you have to wait for your interview, and then you have to do your medical exam, and then there's also this VAC appointment where you have to undergo biometrics and fingerprints before your actual interview at the embassy. So these cases apply where you have an approved I-130 petition, either as an immediate family base or preference category that's now available, or an I-140 through employment-based cases. So example, same as the adjustment of status, like you get married to a citizen, petition from your parents, petition from your employer, but you have to do it outside the interview at the consulate abroad. Typically, mga kababayan, this applies for people outside the US because they don't have a visa in the United States, or they prefer that consular processing is a way to go instead of adjustment of status.
Yeah, so now kailangan lumabas. But ito, attorney, napakarami na kagad ng mga tanong. I'm sure over the weekend, people have been reaching out to you. If it's going to be consular processing, going home in the Philippines and everything, napag-usapan na rin natin na ilang beses na rin na talagang may backlog sa, brought about by the COVID before pa. And so, mahaba ang mga waits and everything. If this is moved from AOS to a consular processing, mas haba ba ang kanilang hihintayin sa tingin niyo, attorney?
Definitely, there would be more backlog and waiting time process for a family-based case, especially mga nasa preference category, even immediate relative. After your case documentarily qualified, you still have to wait about 6 months to a year, to even 2 years for preference category. Now, in cases for for people already in the U.S., there are situations where they are not able to adjust status because of their type of visa. Mga kababayan, for example, if you're a crew member, right? You entered as a crewman, you entered without inspection, you don't have valid document when you enter the United States, you came in as a K1 visa, a fiancé visa, and you didn't marry your petitioner. Now you find someone else, right? Either another U.S. citizen spouse who filed a petition for you. But before you leave the U.S., this is what we call 601A waiver, where you ask for forgiveness because, people who already overstayed, you all know that it will trigger the 3 or 10 year bar once you depart the United States. And that's the common problem that we see aside from the backlog. Mga kababayan, once you go home to your home country and you accrue more than 6 months overstay, you are 3-year bar, and if you overstayed for more than a year, then you are 10-year bar. So departing the U.S. will trigger those bars, and you cannot come back, without those waiver. And the waiver after the interview, the waiting time is also 3 to 6 years. And if your waiver is got denied, then you're stuck to your home country forever until the waiver is approved or until the passage of that 10-year bar. Unlike in a situation in adjustment of status, mga kababayan, and the good thing about the adjustment is that, you're in the U.S., you establish a life in the U.S., you have your family in the U.S., you take care of your spouse, your children, your parents, you go to your work, you pay your taxes. And that's the beauty about, having a petition or pending adjustment of status instead of you departing the US. So yun ang kinaganda difference between adjustment and consular processing if you're already in the US. Now, the memo that is passed, that's why people are panicking and people have a concern because the memo says extraordinary, right? We only approve cases in extraordinary situations. Like it's an act of grace. It's no longer like a kind of discretion that in the past, if you look at the adjustment where you marry a US citizen, you are able to prove that the marriage is bona fide. Right? You have a valid documentation, the I-94, right? No criminal records, no misrepresentation, and as a matter of discretion and as a matter of law, they give you the green card. And remember, during the last administration, where it's more of filing, documenting the relationship, and once they believe your relationship, then you get your green card in the mail. Now, they have to consider the positive and the negative factors. Let's say you've been in America for 10 years and you've been tago ng tago, and then you are working without work authorization. Plus, aside from that, you are not filing your taxes, and this would be a negative factors. So that's why it's really important sa mga kababayan natin to watch out for any updates, because this is only the first day, first calendar day, business day after the memo was issued, and many people are scrambling on how to navigate and how to advise our client moving forward. So itong extraordinary circumstances na to, it's not totally na ineradicate or tinanggal ang adjustment. It doesn't also mention extraordinary situations, kundi it's weighing in the positive and the negative factor. And even before the passage of this memo, there were already some immigration officers nationwide, that denying cases based on discretion. Discretion meaning that if you have an arrest, if you have a DUI, and even if those were only arrests that did not lead to a conviction, those are also discretion. Unlike in the past where, the crime does not constitute a deportable offense, and exercising a discretion because this happened more than 5 or 10 years ago, then this should not impact your ability to get an approval for your adjustment of status. But now it's all like weighing in the positive and the negative factors. It looks like you're filing a waiver. Remember our discussion when you commit a fraud, you have a criminal records, right? And then you have to show that there's a rehabilitation and weighing in between the positive and the negative factors.
Ayun, so mas mabusisi talaga ngayon. So, attorney, which particular immigrant group do you think will be most affected by this new memo?
Yeah, the majority of the adjustment of status comes from the family base, especially the immediate relative, because that's when you get married today for a U.S. citizen, then you can file your adjustment right away, right? Or you have a son or a daughter who's now 21 years old and you're here, they can file for your adjustment of status. Likewise, mga kababayan, employment-based, marami rin affected dyan, lalo na yung under H-1B, right? So those are mostly affected in the United States, or people who already overstayed and married, as we mentioned kanina, U.S. citizen. So it's really important to consult a lawyer, if you get married, plan to get married, filing to file, right, to consult a lawyer on how to file your adjustment of status.
Is there going to be any effect on the, you mentioned the employment-based petitions. If, say, for example, a group of employees are currently serving an underserved nursing position, for example, very common sa atin, and then they're, instead of just going to do the AOS or adjustment of status, they would have to go home to the Philippines and wait for it. Don't you think that will displace itong workforce, magkukulang ang mga nurses or whatever industry they're in?
That's a good point. It's not just registered nurses or other medical professionals, also software engineers and other H-1Bs, right? Teachers, right? So how can you say that going to the home country to do the consular process will disrupt definitely the workforce, especially yung mga registered nurses, because as we all know, they still a strong demand for registered nurses. Kulang tayo eh. So, magkakaroon talaga ng problema, right? So, the scenario here, for example, on people who are in a legal status, like say you are H-1B and then or L1 or other type of or student visa, other type of non-immigrant visa, while the I-140 is pending and approved, for example, and you do consular process, what's going to happen if this is going to be implemented is that you have to process while you're still in the U.S. on a legal status, right? Now, you only have to go home once you get the interview. So, for example, the I-140 has been processed and approved. You are in a valid other type of non-immigrant status, right? And the process, go through consular process, go to the NVC, and then wait for your interview, right? Don't go home when you file the petition, because as we all know, there is a waiting time for preference categories, and even registered nurses, there's a waiting time of about 3 years, 2 to 3 years for the priority date to become available. So what happens if you are here on a legal status, then you have to wait for your interview, and that's the only time you go home. And hoping that, going home, meaning that you have to undergo your medical exam, right? You have to go to your VAC appointments, and then you go to the interview. The problem here, Kuya Johan, even if you just need to go home at your interview, you still have to take a leave at least 3 weeks to a month, because you have to do the medical. And also you're anticipating that there might be some administrative delays. What if St. Luke's require you to undergo a sputum test that will take about 3 to 6 months to a year, right? And then there's a problem with your fingerprints, there's a problem on your civil documents that will take the administrative investigation on your case that will take quite some time. So then that would be that disruption. We cannot just say that you have to go home for 3 weeks only, para ka nagbakasyon, which is fine. But what if, these situations happen? Now, the biggest problem here are people who are overstayed, right? As we mentioned kanina, because what's going to happen to them, going home, without a waiver would definitely, cause them to be staying outside the U.S. for a very extended period of time.
That's why, understandably, people are panicking since this was out in social media. Everybody was covering it, and long weekend pa naman. So I'm sure maraming mga nag-reach out sa iyo during the long Memorial Day weekend. Pero Attorney, one of the questions na natanggap natin dito sa ating radio station is that, does this apply to those petitions or AOS submissions that have been forwarded to the USCIS before May 21st, nung lumabas itong memo na ito, or it only applies to the ones moving forward from May 21st?
The May 21st memo does not specifically state or clearly limit its application to newly filed cases, right? Normally, the law has no retroactive effect, right? But we might be waiting for other what do you call this, like explanation or another memo from USCIS explaining how does this be implemented, or implementing rules rather on this memorandum. We're gonna find out. So what I advise sa ating mga kababayan who have a pending adjustment of status application is document what are the positive factors. Like if you're contributing to the community, you're filing taxes, just make sure that you keep them so that once immigration requires, assuming that it applies to you, even if you had a pending application a year ago, a month ago, we never know. So we have to wait for the instructions rather from as for evidence, require you to submit more documentation or be proactively submitting them. So we have to wait for further instructions from USCIS.
Also, Attorney, are there any immigrant groups that might be exempted from this ruling?
Yes, marami sa mga kababayan natin nagtatanong. Unang-una, US citizen, hindi applicable sa inyo yan, right? You're already US citizen. Pangalawa, secondly, if you are filing for naturalization, right? You have pending naturalization, this memo does not apply to you. It only applies for people who are filing for adjustment of status. Number three, people who are filing for removal of conditions, right? Let's say you already proven that the marriage is bona fide and that your green card was already issued although it's 2 years, and then you have to file a removal of condition, this does not apply to you. Pangatlo, yung mga nagpa-file ng adjustment through asylum, right? The asylum was granted, this does not apply as well to you, or diversity visa, although marami hindi kasama ang Pilipinas sa diversity visa. Other countries, have this diversity visa. Yung mga nasa 245I, also like, you're covered under the prior 245I law during President Clinton's time, the 1998 and 2001. This may not apply to you as well. So lahat ng mga yan, and also the trafficking and U visa, these applications don't apply to you.
Attorney, in your many years of handling these cases, most especially those who are affecting our kabayans and reuniting families and everything, what do you think are the factors? Because when you say discretion, alam mo, mga pang-lawyer na terminology yan eh. Discretion. But what do you think are the factors that may move the officer to consider na pwedeng itong particular case na ito ay, sige, adjustment of status na ito, we'll approve this. What do you think are the things, family, whether mahihiwala yung family or work, or what do you think are some of the factors that may sway them to approve an AOS instead of doing the consular processing?
That's a great question, Kuya Johan, and that's what I advise sa ating mga kababayan who have a pending adjustment of status or is planning to file one. What are these discretionary factors to consider, and what are the documents that they need to prepare, especially that we don't have an implementing regulations as of yet, right? The positive factors, like when we're dealing with waivers, it consists of your family relationship in the U.S. So your parents are here, your brothers and sisters, it would help. Your son, right, served in the military, right? Your spouse was or currently serving the U.S. Armed Forces. So those are the positive factors. Family relationship is a big factor. All your relatives are here. You don't have any more, home in the U.S. You have a house in the U.S. You have a mortgage in the U.S. You're paying your real property tax. You're contributing to the economy of the United States. Those are positive factors. And even, mga kababayan, even volunteer work, right? Like what we do sa Philippine Consulate. We volunteer some type of work, right? Not only like a big organization, simple act of kindness, like you go to your church and, nagbibigay ka nag-issue ka ng cheque, kahit $10 lang, di ba, for the Catholic Church or whatever church you're attending to. Those are very helpful. For example, you feed the hungry. May mga organizations na ganyan, di ba? Or you volunteer at your child's school, kayo yung nagta-traffic, di ba? So, those are type of, positive factors that immigration really want to see, right? That you are, you are deserving to be an immigrant in the United States. So you're paying your taxes, hindi ka nagtitake advantage sa sistema, right? I mean, even with a TIN, you're paying your taxes, you're building, you are also going to school. Let's say, kumuha ka ng mga short courses, CNA work, CNA, certificates, tapos nagtuloy ka pa ng nursing, stuff like that. That is showing the positive factors. And also, you have to also obtain from your city that you don't have any criminal records. So those are the positive factors that you need to show to the immigration. And be proactive. I mean, what I advise sa mga kababayan natin is keep them now. And once immigration requires that, you're ready to show them and file it to USCIS.
I remember many episodes ago, many years ago actually, napag-usapan natin yung good moral character. And I'm sure ang ating mga kababayan, well, if I have good moral character and doing all those things na ginagawa, nasabi nyo, volunteering in the church and everything, feeding the hungry and everything, that might be a good and positive factor. But like what you mentioned, kailangan siguro i-document mo ito kasi how will you prove that you're part of this organization? So probably documentation. It goes without saying, attorney, that the flip side of all those things might be the negative factors. If you have some record or not filing taxes or something, ano po?
Yeah, I mean the not so good thing about this is, like as we mentioned kanina, overstaying and working under the table. Right, in the past, if you marry a U.S. citizen or you 245I, that should not impact your adjustment of status application, right? But now, if they said, oh, you've been here in America for 20 years, what have you contributed to the US, right? You've been manipulating and, using the system to your advantage without paying your taxes, so those are the negative factors. Even DUIs or drinking under influence, even simple traffic violations, because it's showing up on your records. Those are the negative factors, right? Arrests and convictions, of course, those would boil down to a negative factors in determining whether they exercise discretion in your favor.
So, if and when the application for AOS is denied, ano yung mga pathways nila, attorney, na pwede nilang gawin?
Yes, it's tough call because either what we do right now, even before this memo, is that if your adjustment of status is denied, we can refile, refile again, and try again, and see whether there are changes to your circumstances, right? Let's say in the past, you don't have a spouse who had medical condition, but now it's showing that I cannot leave my spouse because he just had this problem, or you just have purchased a home, etc. So you have to evaluate the reason for the denial, and if there's a strong evidence to refile, then you have to do it. Secondly, the problem with the discretion is it's hard to appeal this type of cases where it's a discretionary matter, right? Probably if there's an abuse of discretion, you can either file a motion to reconsider or reopen the case. The third option, the filing motion to reopen, reconsider. If you're going to you don't do anything, we expect that the USCIS will issue you a notice to appear, meaning that they're trying to remove you and forward your file to immigration court, where they're going to issue a notice to appear and appear before the judge. In that situation, in a family-based scenario, the judge can probably evaluate your case again. So this is what we call two bites of the apple, where immigration says, I don't believe you, I'm going to deny you. Now you're going to appeal the judge, and that you have to renew that before the immigration judge and evaluate again and provide stronger evidence showing the positive factors in your case. So that's another option where you have to refile. Now, the third option, if your adjustment of status is denied and you are still in this status, let's say you're still on a student visa or H-1B, then do the consular process, right? But, again, as we mentioned kanina, there are problems, when you go home that might delay your stay outside the U.S. if you do consular processing.
That's right. And mga kababayan, this memo is very, very fresh. Like what we mentioned at the start of the program, this happened shortly before the Memorial Day weekend, and everybody went on a break, and then we're just coming back again to work. So mga kababayan, abangan lamang sa mga social media pages ng Reeves Immigration Law Group at ni Attorney Diza, FJ Diza, U.S. Immigration Attorney, para po makita at mapanood at mabasa ang mga iba pang mga updates as we move forward with this. I'm sure, Attorney, meron kang mga bilin sa ating mga kababayan, I'm sure, when navigating this very, very fresh memo. What can we tell them, especially those who are panicking, Attorney?
First and foremost, mga kababayan, do not panic, right? This memo is understandably created concern within immigrant communities. While there are reasons to be cautious, this is not necessarily the reason to panic. What we always advise, even before this memo, is preparation, documentation, and be proactive. That this matter more than ever, right? You should work closely with your immigration lawyer to strengthen your case and understand how evolving U.S. policies may affect you. So those are the important things that we advise them. And also, as you mentioned, to check our USCIS, rather our website at Reeves Immigration Law Group, our social media platforms, Facebook, Instagram, LinkedIn, and also my personal social media, FJ, as you mentioned, Karina, FJ Diza, U.S. Immigration Attorney, where I do usually update, parang tawag nito right away. I put an update right away just to ensure that our kababayan will be informed of what is going on. I also, in a way, on my social media, Facebook account and Instagram, updated and place a brief summary of what the memo is and what we talk about today, just in case you missed this program. You can also check our social media and also listen to this program. We keep updating you on what's going on with U.S. immigration.
That's right. FJ Diza, U.S. Immigration Attorney. That's the Facebook page that you can follow, mga kababayan, for up-to-date information. In fact, nung lumabas ito, nandoon na kaagad sa social media pages the Attorney Diza. Well, Attorney, maraming salamat for giving us an update. And I'm sure ang ating mga kababayan, marami pang mga tanong, but we'll keep it brief for now. And surely we will follow up on this thing, on how this is being implemented, and especially how this is affecting our immigrant community, especially in the Filipino community. Speaking of the Filipino community, Attorney, I'm sure a lot of our kababayans siguro ay dumudulog ngayon, siyempre sa mga kapwa nila Pilipino, mga lawyers, and especially our mga magigiting na mga public servants dyan sa ating konsulado dyan sa San Francisco, where you are, para humingi ng tulong or medyo siguro advice. And I know that you continue to do your pro bono work with the consulate. Attorney, invite our audience to avail of those services.
Maraming salamat, Kuya Johan. And before invite them to our pro bono services, I would like to congratulate PHLV Radio. Is it second or third straight year that's awarded for 2026 Phil-Am Media of the Year. Thank you, PHLV Radio. I'm so proud, of what we've been through all these years, right? And be a part of the success ng PHLV Radio. America Prestige Awards also, Mr. Sam Azurel, which we have attended on May 23rd, despite what's going on with immigration. And also thank you for the award for the outstanding immigration advocacy, right? It's not only through our pro bono services at the Philippine Consulate General in San Francisco every first Friday of the month from 10 a.m. to 3 p.m. Also with the Asian Community Development Council, I provide Zoom consultations through the ACDC, and also the FBank, the Filipino Bar Association of Northern California, and some immigrant non-profit organizations. Kuya Johan, siguro kung ako nag-apply ng green card with all my volunteer works, there's an extraordinary circumstance to approve my adjustment of status. But kidding aside, of course, lahat ng mga viewers and listeners ng PHLV Radio, maraming salamat sa inyong lahat. Keep watching and listening to all the programs of PHLV Radio and also our program Immigration Law on Your Side. Maraming salamat at mabuhay.
Mabuhay kayo, Attorney Diza, and back at you, Attorney. Congratulations as well. Katulad ng nabanggit nyo, mga kababayan, si Attorney Diza ay ginawaran ng award, ng America Prestige Award, ng Outstanding Advocate for Immigrant Justice Award noong Sabado, mga kababayan. So congratulations po kay Attorney Diza and sa Reeves Immigration. Maraming salamat for this journeying with us sa ating public service dito sa ating Immigration Law on Your Side. So Attorney Diza, maraming salamat once again, and eto na, summer na, painit na ang Las Vegas, mas painit mga kababayan ang mga pinag-uusapan dito sa Immigration Law on Your Side. So surely dapat tumutok tayo dito sa ating palatuntunan sa susunod po, mga kababayan. Kuya Yo, galing sa Las Vegas, we will see you again next time.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.